Hey folks, welcome back to the Edupedia world, and I am Abhinay Gupta. And today again we'll continue with the topic prevention of oppression and mismanagement. Right? So folks, in the previous lecture, if we notice, right, we have seen the basic of this chapter. Right? We have understood the origin of the chapter. Right? It is there to defend the minority from the rule of the majority. Getting the point, right? So anyway you see, right, the majority rule prevails. You look at the board, a resolution is passed in the board meeting with the majority of the directors. A resolution is passed in the general meeting only when the majority of the shareholders, they consent to something. They give their consent, right? Otherwise it is not passed. Anywhere and everywhere you see the decision on the behalf of the company is taken either by the board or by the members. And in any case, it is always taken by the majority, right? But this majority can at times go ahead and be a little oppressive on the minority or go ahead to mismanage the company, right? There can be situation because the majority will not always be right. It's not by fluke always, it is also by intention that they're wrong. Okay, so this chapter basically will focus upon correcting those problems, right? So let's do one thing. Let's quickly hop on to the next section, which is section 397. This is a very good section, right? You get to understand the depth of it, of what oppression actually is. And if you, as an individual, as a minority, want to claim oppression, claim relief from oppression, right? What are the conditions you need to satisfy? Right? What are the conditions that have to be fulfilled to consider the situation to be oppressive in the first case? And once it is oppressive, then how do you claim the relief? Right? So, and basically we'll see the situation in the case of quasi-partnership. Like if you get to the crux, then all those things that we're talking about will, the majority part of it, right, would relate to a quasi-partnership. You know what a quasi-partnership is? You must have read about it in your IPCC as well, the quasi-contract and stuff. So quasi-partnership is basically a company which is formed in the internal of a family. So the joint family, they come up, they have a common business, they operate it like a private limited company, but is more sort of partnership. That means the shares are divided, right? The cut is given to, okay, this family member, this family member, this family member, this much is my share. So although they operate like a private limited company, but their modus of operandi is like a partnership, right? So that is a quasi partnership. And in that quasi partnership, right, there are a lot of things that need to be taken care of because it is not like a normal company. It's a family owned business, right? So we'll see what happens and what steps do we take in the quasi partnership also. But that will be done covered somewhere towards the end of the chapter. Let us first understand the basics of operation and the relief from oppression, right? So basically, the defense from oppression has been bought by the section 397, right? So that the majority should not enrich itself at the expense of the minority, right? So this is one position where the majority rule is diluted, right? The power from the majority is taken away. Okay, so once we understand there are certain conditions for claiming the relief from oppression, and only if these conditions are satisfied is when you can go ahead to claim that, right? The first condition says that the oppression should be prejudice to the public interest. Now, what do you mean by that? This means that the company, right, it is not talking about the majority or the minority. When we talk about something being prejudiced to the public interest, we're talking about the actions of the company, the affairs of the company. Right. So if you look into the affair of the company, it should not be conducted in a manner which is oppressive to any member first, and should not also be conducted in a manner that it becomes prejudice to the public interest in the large. Right. Now understand the company. Now how does the company perform? If the company is a separate legal entity, it has no hands, no mind, nothing. Right. The management thing is taken care by the board, and the decision making is done by the shareholders. Right. We know that. So if the company is doing something, then if we look at the back end, if we lift the corporate veil, it has actually been performed by the members of the directors. So what this section says is that any action taken by those members of or directors, right, it should not be oppressive to any member in particular or to some member in general, right? Plus, those actions should at no time be prejudice to the public interest. Right? So the company tries to get into some hooks and corners to just get out some profits, undue advantages, right? And that is being very much prejudicial to the public interest. So that is a situation where oppression would pop up, right? So when we talk about oppression basically, then it is about some act that has been done by the company which is burdensome, which is harsh, which is wrongful on any individual member or to the public in general, right? So there is lack of probity, lack of fair dealing by the company, right? So if any of such situations take place, right, where the actions of the company are being very harsh, very rude, right, then we would say that okay, the company is trying to be a little oppressive. That is when we say the oppression takes place, right? But it is not in isolation. That okay, if the act is prejudicial to public interest, we'll say it's oppression. No, it's not like that. There are other conditions too that has to be cumulatively fulfilled to prove that the situation results to an oppression, right? So the next situation that we see is that oppression should be in the capacity of member. A very important line to understand and remember, right? See, you will be getting a lot of questions in your examination from this chapter. When I say a lot of means, not in a single paper you'll get a lot of questions, but if you look over your examinations pattern, you have had questions from this chapter, right? So when I say a lot of questions, means there are a lot of questions that can be made, right? And in every particular question, if you want to check, right, whether the situation is oppressive to any member or not, these are the conditions that you have to check one by one by one. First, is it prejudicial to the public interest or is it oppressive? Is it harsh in some manner? Second, is it oppressive or harsh only to the member? Because oppression is related to the member itself. No other capacity. No capacity of the individual, may it be directors, creditors, no. So if the majority is being harsh on a director, the director cannot claim relief under this section 397. This section is specifically made for the members. So if a member is facing any trouble, right, the member can claim relief from oppression under this section, right? It always has to be in the capacity of a member. So if you ever see that the majority of directors, they override the minority of director, right? Then those minority directors, they cannot go to the company law board under section 397 to claim relief, right? Similarly, something happens with the creditors of the company. Even the creditors cannot go to the company law board to claim relief under this section. Yes, they can claim relief, but there are other sections made for that. But section 397 of the Companies Act 1956 has specifically been made and customized for the members, right? Now, continuity of oppression. This is something you need to understand. See, oppression is not an isolated act. That okay, the majority they one day took a decision and that decision was a little harsh on the minority. Do you think the minority can rush to claim oppression on that? No. Because, okay, before getting ahead with all these conditions, one thing I want to make you are very clear with that oppression is just an alternate to winding up. Yes, you heard me right. When we talk about a company reaching a certain level of default or prejudice or anything where the company is supposed to be wound up, right? Then an alternate to that winding up is to claim relief from oppression. This is not for all types of winding up, but this is for a particular type of winding up that we are going to see in this chapter in oppression and mismanagement. So oppression generally is just an alternate to winding up of the company. That means it is trying to seek some good results rather than just simply wind it up, right? So first, there should be continuity of operation. So a member, if they go to the court or the company law board to claim relief from operation, then they should be going in the period when the operation continues, right? And only if it continues that it becomes or it takes the company to a situation of winding up, right? If it's an isolated act that's just happened once and is not happening again, right, does not mean that it's oppressive and you just go ahead to claim relief over there, right? The continuity has to be there. right? So that is again a very important consideration to check oppression. Moving on, the justification for winding up, as I told you already, right? That prima facie the degree of oppression should be so severe that it should be just and equitable to wind up the company. And when the court thinks that yeah, it is just and equitable to wind up the company, that is when they see, is there an alternative? Can they claim relief under oppression? If yes, they can go ahead and they'll relieve the minority from that oppression. Otherwise, if that is not possible, right, the court has been trying, but there is no relief that can be provided to the minority from this oppression, then in that case and scenario, the company needs to be wound up. Getting the point? And the last, winding up is prejudicial to the applicants, right? So understand, if the company could be wound up, why don't they wound up? Why don't they wind up the company? Right? Because if the minority is being oppressed, right, and then the company also winds up, there is a high probability that the minority is still under the oppression. That means the majority who loses is the minority. Getting the point? So instead of winding up, because winding up will not be of any help, right? It would defend the prejudice to the public interest, but if I talk about the minority, the winding up will not help, right? For example, if the members, right, they have passed a resolution and then taken away the shares of the minority. It's a resolution, like maybe they pass a special resolution to take away the shares of the minority. Then, as per the law, the resolution is passed, the action begins, right? And now the minority they run to the court and the company law board to say, hey, stop, 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 these people are taking away our shares. And the court says, this is a very typical situation, right? I don't think the company should operate this way. Let's wind it up. Now, do you think by winding up that company, those minorities will gain in any way? No, because the shares have already been given to the majority. And in the case of winding up, when they get the return, the majority gets the return. The minority still stays over there. The winding up is not actually a rescue for that. Right? In that situation, if winding up is prejudicial to the applicant, somebody who is applying for that claim relief from oppression, if the winding up is prejudicial to them, then we go ahead to find out a solution from this oppression. Right? Are you getting the point? So when we talk about claiming relief from oppression, these are the 5 things that you need to keep in mind. Number one, it should actually result in oppression or it should be prejudice to the public interest. Second, this operation should be conducted or should have been occurred in capacity of a member. So if you are a member and the operation occurs to you, then we consider it to be oppression. But we consider it to be oppression only if it is a continuous act, right? Plus, it is just and equitable to wind up, but we cannot wind up because winding up would be prejudicial to the interest of the applicant itself, right? That means the company is oppressing whom? The members, and that is being in a continuous process, and it has been so severe that the company could be wound up, but we cannot wind up the company. Why? Because it would be prejudicial to the interest of the applicant as well. So when this series is complete, right? Only then the court goes ahead to give them the relief from oppression, right? Now, this is the condition that we have seen. Now let's get into a little more discussion on this, right? As to what amounts to oppression, right? The first thing as we now this is the brief that has been given in section 359. But now if we go ahead to understand this in detail, right, then we say that oppression must be continuous. The conduct must be burdensome, harsh and wrongful. There should be lack of probity, fair dealing, all these things we have discussed, right? Then understand it is not just enough to show that it is just and equitable to be wound up, right? Because it has to be in series. Only when there's a situation that the company should be wound up doesn't mean it's oppression, right? It's oppression only if there's some harsh action going on against the minority, right? And it's oppression only when the winding up cannot be conducted because it would not benefit the minority. It would be prejudicial to the minority, right? So these situations have to be there, right? And you cannot consider any particular act or event in isolation to be an act of oppression. When we say oppression is a continuous process, That means there has to be a series of acts to prove oppression, right? Then another thing that you need to take care to understand is that there should be some visible departure from the standard of fair dealing. That means, okay, this is how it should be dealt fairly. But now they have made a twist or they have made a shift, and that is a departure from the fair dealing. And it is not a minor departure, it's a very visible departure. That this is what was supposed to be done, but this is what has happened, and there is a big gap between the two, right? So, should at the lowest involve a visible departure, right? When we say that there's a violation of any condition, right, it should be a violation of a condition of fair play, right? So they're all the shareholders, they entrust some money on the company, right? And then the company performs in certain parameters and certain ways in order to excel, right? But if you see that there's a departure from the standard of fair dealing from the company's end, right, all of them get impacted, right? So there has to be a major drift that is to be visible, right? And there should be a persistent and persisting course of unjust conduct. And this is something that has to be proven by the member, right? So if we say that yeah, there was a shareholder who was also a director of a company, right? And that person disregarded a resolution of the board, right? So understand, there's the members. Now this is again where I'm talking about the quasi-partnership kind of a thing. The members, right? The member, somebody who is holding a majority share is also a director. And that director manages the company as if it's his own company and no one else is involved. So whatever he wants, he does. Whatever he wants to take forward, whatever action he wants to take, he does because he has the majority shares and is also the director, right? Then that would lead to oppression, right? Now, if you are forcing something risky, right? If that action if taken becomes risky to the company, but the majority is forcing that action to be taken, then that would result into the same, right? So, for example, it's an insurance company, right? And the majority says that that a certain insurance has to be taken up. They have to back it up, but they know that it would be a very great loss. It is not supposed to be insured or something, right? But what do the majority do? They take up the insurance and push the burden to the minority. And now minority is in a great threat because at any point of time that insurance can mature and the minority will have to pay for that. Right. So this is just an example. So they can be forcing anything upon the minority. They pass a resolution that okay, these minority shareholders they're supposed to do this. These minority shareholders are supposed to sell their shares at this rate. These minority shareholders are supposed to be keep shut. They're not supposed to attend the meeting. Whatever, right? Whatever. If you are forcing on any action on the minority, it would result to oppression. Right? And when we say that only members can claim oppression, right, then we need to understand that if, for example, a petition was brought for the collateral purpose for forcing the repayment of a loan to some other company, right, in which the petitioner was interested. So this was an abuse of the power. I am a member of this company, right? What I do is I also hold a majority share. What I say to the company is to please pay off certain loans and certain things of the other company. Why? Because the other company is also my company. I own majority shares in the other company. So I say this company, please go and help that company. That means if I say company A to go and help company B, that means the minority in company A, right, is at trouble. Why do they help my other company? Why do they pay for that? Right, but since I had a majority, I took a decision. So that is not correct. Right? And you cannot file any petition in capacity of a director and all we have already discussed. Right? And whatever I'm doing should be just and equitable to wind up the current company where I am performing those acts. Right? But if some act has been performed due to lack of my knowledge, like if I was the person taking those decisions and I was actually not informed about certain facts, or maybe there was a misjudgment on my end or lack of knowledge that I took some steps, then that will be considered as a mistake, right? That is not a deliberate action from my end. So that will not result in oppression. Okay, we need to take this thing in mind. Now let us specifically discuss about the quasi partnership that I was talking about in the beginning of the chapter. Right, when we talk about the quasi partnership, you remember, right, what a quasi partnership is. The action is performed like a private company, but actually in the backend, if we see among the shareholders and directors, they act as if they are equal partners, or they are partners, where the shares are divided or the profits are divided in certain proportion. Right? So that is something we need to see. If that is the situation, then in a quasi contract, the members, the directors, all of them are the family members. In that case, if a director is removed by the other directors who are in majority, then that director can claim relief under section 397. Right? Like, understand. So if the members have the full right to remove a director, you know that, right? And those rights are unrestricted. So if it is a quasi partnership, right, then the members who are themselves the directors, the majority members, they say, okay, there's a partnership, for example, A, B, C, D. A, B, C, they are a majority and they say, okay, we will remove D as a director, right? So in this situation, the director is removed as per the provisions of section 284, right? But this director can claim relief in section 397 because the director is also a member. Although the operation has not occurred to him in capacity of member, but has occurred to him in capacity of director. But since it is a situation of a quasi-partnership, we would allow that, and that director can claim relief under section 397. Right. Now what happened is there were two families involved in that family business. Right. Now both had equal partnership. When I say equal partnership, they both have maybe three members each in that business. Now the first family, they introduce a fourth member and hence gains a majority, and then take certain decision to be harsh or wrongful to the minority, then that would be considered to be oppression. Right? So if they appoint any additional director in the family concern to marginalize their authority on the over the other group, then it would amount to oppression. Whether they do some act of oppression or not is not material. If they're taking this step and that is reducing the power of the second, right, then we would say that okay, they are oppressing it. Right? Now the board is balanced. Now you increase the members so as to imbalance the board. It is the oppression on the minority. Right? So it's a family holding. A, B, C, D is holding the shares of the company. Now what happened is A, B, and C, they removed D, or they did not involve D, and issued more shares for themselves. And that imbalanced the shareholding. It is an oppression to D. Right? So they increase their capital by themselves so as to acquire more voting right. It is an operation to the leftover member. Right? So these all things also you need to keep in mind when we are talking about oppression and when we are actually talking about claiming relief from oppression. Right? There's no article that can restrict any of these acts. Right? Any proceeding under section 397 cannot be barred or defeated by any article or any memorandum or any agreement. Whatever 397 says has to be done. The members cannot play smart on that. Right? So that is all about section 397. I know it went a little lengthy. Right? There were a lot of things to discuss, a lot of small points that we have been focusing out. Right? So this entire lecture, right, I understand must have been a little too much for you. And it is difficult for you at the end to grab, oh, what has happened, what all things have been discussed, right? I know that. But still my purpose to give you all this information loaded in just one lecture was that in the next lecture I'll be picking up case studies. And in those case studies I will be reflecting to whatever I have said in this lecture. And then things will be clear to you. Right? So if things are not very much clear to you in this lecture, please do not panic for that. It's not a difficult chapter, it's a very simple chapter. There are bullet points, right? Just because I was explaining, I elongated those bullet points. But in the next lecture, when we are discussing the case studies, I'll bang on to those bullet points and seep it into your brain. So don't worry about that. I'll see you guys back in the next lecture. Until then, this is Abhinay Gupta signing off. Thank you and bye bye.